Well, good afternoon and happy Valentine's Day to everybody, to my Family Forward peeps here who have joined me for training number 13, Family Forward Project. And today we're going to be talking about the CPS timeline step by step. So again, thank you so much. Thank you all who have been loyalists and have worked through all of these videos and trainings. If you have missed one, they are up in a YouTube channel called Family Forward. You'll find all the trainings listed there. Also, I'm putting them up on a different, posting them in a different website as well as the Google Classroom. They are also found in the Family Forward Project group on Facebook on featured posts. So if you're on a computer, the featured posts show up pretty easy. If you're on a phone, you actually have to click on the little button for featured, and then you will see where the trainings show up. I am downloading and uploading both audio and video. So there are some people who who learn better by listening than they do seeing and listening. And there's some people who like to see and listen. Honestly, I think sometimes on complicated issues, it's better just to hear it first and not get confused with visualizing it and hearing it and everything at the same time. But either way, some people like to see it, and I try to stick pretty much on script so it doesn't confuse your brain. But we do have a lot of conversations based about what you're going to see on the screen. So there's going to be today when we watch it, there's some listings, and we're going to then stop, and I will of course talk about. And as always, I fill in with a lot of experience I've had over 30 years to tell you the good, the bad, the ugly about all of that. All right, so we are going to flip over to a screen. Maybe if it lets me. Okay, so you should now be seeing in front of you the slideshow. Let's see. Jen, can you give me a thumbs up if you can see the PowerPoint? Very good. All right, thank you. Let me move this little thing out of my way. All right, so this training is the CPS timeline step by step. This is really kind of a misnomer, I'm going to tell you right off the bat, because there is no step by step in this process, as you can see as we go through it. While you are watching this video, I'm going to encourage you to make yourself some what if notes, okay? So those of you who've been through the process, you know, and you've personally experienced a lot of hiccups, but as you are talking to other people going through this process, and I want your people to be able to look at these trainings to help them sort of understand this process just generally. And then as you're watching it, even today in the training, think, well, what if this doesn't happen? Well, what if that doesn't happen? Well, what if? Because as we know who've been through this experience, what if is like the secret code question, right? Because all kinds of crazy things happen. Okay, so let me figure out how to get us past to the next slide. Hold on. Up, there we go. All right, so basically, just like we have talked about over and over and over and over, the very important things to do is prepare. So we're going to talk a little bit about preparing. We're going to talk about asking questions. One of the things that I have found is that parents get involved with this process and there's too much trust involved. They have too much trust that the system's going to do the right thing, that the system's going to ask them the questions, right? But they don't. We know they don't. So what kind of questions maybe can people sort of learn to engage in and ask? Documenting, of course, I say that all the time, document, record, timeline, plan, all of that, even, before we even start going step by step, that's a very important part of this process that we want to create a mindset around. We want being prepared, asking questions, documenting, recording, creating timelines from the very beginning, and of course, planning always for the next step. All right, so first of all, we're going to talk about the knock on the door. Make sure I can see my own screen here. I can. All right, so the knock at the door. This is a question I felt like I had to put in here because there's a lot of people out there on TikTok and YouTube, and they're like, if they knock on the door, tell them to go away. If they knock on the door, don't let them in. If they knock on the door, tell them to whatever, right? So I don't recommend that. And I don't want it to go haywire from the very beginning. What I want people to do is be proactive, for them to be engaging citizens and be proactive in this process. So you have to remember, number one, that the agency has a statutory duty to investigate. They have to investigate by law. And there is a priority placement that they have to put on that investigation. However, also by law, they have a duty to inform. And I know even under Tennessee statute, when it talks about the investigation, it says that they should inform the alleged perpetrator of the allegations against them. They don't like to do this. I'll tell you, to be clear, they do not like to do this. And sometimes you have to force them into that process. When you're going to immediately start documenting audio, video. I have a client who has I'm going to mute somebody here. So I have a client who put her phone to her side and documented them knocking on the door. And I was going to share it today. I didn't have time to get it worked into here, but I am going to put it in one of our training videos. Now, this person didn't know that she was recording, which is fine. But when she got up to trial and she testified that mom yelled at her and was screaming at her as she went back to her car because mom told her she had an attorney, it was absolutely false and it was not true. So we want to make sure we're documenting from day one. All right. Also, immediately getting the names and the contact information. Who are these people standing there? Who are you? What is your name? What is your badge number? If you're working for the agency, what is your name? Who do you work for? Do you have your credentials with you? Okay, that's important. Get names and contact information immediately. Now, show the child. This is one that's very troubling to a lot of people. But as part of their statutory investigation, they have to see the child. Okay. Here's what I want to avoid, because they use this, is if they get a hiccup somewhere from this very first knock on the door, it actually gives them a leg up, right? Because now they go to court, they fill out an ex parte petition, and they say, mother failed to cooperate, dad failed to cooperate, they wouldn't let them see the child, right? So they're going to use it against you. So show the child. I say you can show the child at the front door. You can have the child step up to the front door, introduce them, and just kind of make it more of a routine. Now, also, as I always say, if you're a child abusing drug addict, okay, this is going to be a little bit harder for you to do because you're guilty as alleged. But for 90% of the people that we know, and that neglect category that we know is out there by statistics, showing the child is not going to hurt you. Now, I do say avoid entry into the home. So if they do not have a search warrant, or they can also get what's called an investigative order. If they don't have a search warrant or investigative order, we do want to avoid them entering the home. Now, if you have a great home, if your home's perfectly clean, you have no hiccups with your home, and you can record it while they're there, then it's a possibility. But if there's and honestly, in a kid's world, in a family world, homes are rarely perfectly clean. Okay. I raise children. There's always like laundry on the floor, smelly tennis shoes, whatever, dog hair on the floor. So, and they will use every one of those things against a parent. So if they want to inspect the home and, and we find out, then we're going to arrange for that to happen. And then seventh is we want to agree to cooperate. We want to agree to cooperate. Now, we can set an appointment, we can set a time, we'll talk about ways to do that. But the knock on the door, handling it properly from the very beginning is very, very critical. All right, so in this video, I have made several slides about asking questions because, again, we want people to engage from the very beginning. And somebody needs to mute. I'm not sure. Check your microphones and make sure you're muted. So several of these slides, I put together these little speaking slides, asking questions. And here is certain questions you can ask because people want to go like, well, what do I ask them? Again, it's the government, right? So you can say, tell me why are you here? And what is the priority of the investigation? And I may feel like I need an attorney, a lawyer first before I talk to you. The priority of the investigation is very important because they have to prioritize it by 1, 2, 3, or 4. And 4 means that it's not a priority. And honestly, they can have a week or whatever if they need to investigate it. Some of them are even classified as assessments and not investigations. If it is a priority 1, that means an immediate emergency, which is supposed to be immediately or no later than the first 24 hours. And then I think 2 is 48 hours, whatever. But it's okay to ask that question, what is the priority of this investigation so I can help you, right? And if they say it's a priority 1, the next field question is, can you tell me what the emergency is or what the harm is that you're investigating? Second is the removal. Oh, again, so this is a very, very hard thing to do. So there's a removal without a warrant, without a court order. There's a removal with a warrant, with a court order. There's a removal with a petition and a court order. Always again to document in video. And then what do you tell the child? So let's look at the first 2, without a warrant or without a court order. Important to understand that there is a distinct difference between a warrant and a court order. Some people say, do you have a warrant? And most of the time, it's not technically a warrant. A warrant is a very specialized document. However, it can be a warrant. Typically, a warrant would be where there is some type of charge of criminal activity, but there are certain removal warrants that are emergency that they can do. But most of the time, it's going to be without a court order. And so a court order, ex parte, you've probably heard me use that word before, and that means it's done without a court hearing. So they fill out a petition, they put facts in there, they swear to those facts, and they go to court and they ask the court for a removal order. And which is, on the criminal side, it's kind of the same process that they use when charging somebody with a crime, because they do put in a warrant what the crime is and then ask for you to be arrested. All right, then with a court order, we just talked about, okay, so the petition and the court order. Important to understand that sometimes they try to get away with handing you a petition that does not have a court order with it. Okay, they've even tried to do this to me before. They hand a court order and they say, well, here's an order to block, therapy. And I'm like, where's the petition? And they're like, well, we just got this from the court. I'm like, I don't care. Where's the petition? You can't just deliver a court order. You have to deliver a petition and a court order. And then document and video. I think I say that every time. Everybody knows it. Document and videotape these people. They need to be recorded. The only way to expose what they're doing. All right. Now, telling the children. This is a very tricky business. What do you tell a child when they are about to remove your child? And it's heartbreaking. And, a lot of it depends on the age of the child. Teenagers, some can somehow, even though it's not really any easier, they can sort of grasp the concept easier, understand it easier. And then for younger children, it's much harder. Now, I've had situations where we had a child about 6 years old, and this was actually a foreign speaking child. And CPS, they knew ahead of time CPS was coming to their house to take her. The judge signed an order, but they found out about it, and they knew that they were coming to take her. And they treated it more non-consequential for the child. So, they lied to the child. They told the child, these nice people are going to take you out to eat and then bring you home. And they didn't do it to be mean. They did it with good purpose, which the purpose was to try to not have trauma at the removal point, right? Where instead of saying these evil people are taking you away from your home, they were trying to minimize the trauma of that moment. Unfortunately, and what happened after that is now the child is dumped off at a stranger's home. The child acts out horribly because now they're hiding in a closet, they're hiding food in the closet, not understanding what's going on. And CPS used all of that against them. They said, well, they were not, they walked the child to the car, they weren't upset about it. The child was not upset about leaving. And then this horrible child was just misbehaving with out of control. So telling the child is critical. I've had him go to grandpa's house and pick children up and take them out of bed, and grandpa be without, like, I mean, what do you tell? And I've never heard from CPS, what should you tell a child when they're being taken out of your care? It's the most horrible thing to even think of. I mean, some people say, you have to go with them. Mommy's going to work on getting you home, or, but I don't even know. I don't know. I mean, it's like telling a child, there's a monster under the bed and you have to sleep in this bed tonight. It's the most critical thing that nobody's ever given me a good answer to. All right, so these are questions, though. I think parents should ask, can you tell me where you're taking my child? If I have a relative, if needed for safety concerns. So, just letting them know and asking questions immediately about relative placement, and object to the removal verbally and just say, I do not agree with this. I oppose this. I don't think there's any reason for safety issues. I want it well documented. There's nothing about this that I agree with. All right, so the first court appearance, this is the probable cause hearing, or preliminary hearing, sometimes it's called. And the critical aspects is there's also supposed to be a least restrictive finding. There should be the appearance of a court-appointed attorney, a guardian ad litem. My recommendation is never waive a hearing. You should try to incorporate relatives and alternatives, and then there will be a setting of a team, and I use the word team loosely, a team meeting. So the probable cause of the petition, this is one that's been very troubling for me because probable cause is such a low standard, and ultimately they have to prove clear and convincing. But all the judge has to find, according to statute, according to law, according to even federal law, is that there is probable cause to believe the allegations in the petition are true and they can rely on hearsay. So, meeting that standard is almost always going to happen. But the second part of that is there also must be a finding that foster care placement is the least restrictive alternative to removing the child. And so many attorneys pay no attention to that. They don't even talk about it. If the judge finds probable cause, they don't move on to talk about what's the least restrictive and best for the children. The court-appointed attorney, sometimes this is the first time that a parent will see a court-appointed attorney, and sometimes they don't even see him that day because the court goes, oh, I'm going to appoint you an attorney and reset this hearing. And then the same thing with the guardian ad litem. They may have met the guardian ad litem in advance and maybe not. Now, number 5 is important. I, as an attorney, never, never, never waive a preliminary hearing or a probable cause hearing, because that is your first step towards discovery. So I have delayed it, but I don't like to delay it too long, because if you give them just a tiny little inch on this, they're going to take a mile. So if you're going to move for a continuance on the preliminary hearing, you want to immediately, while you're there, get another date so nothing falls into the darkness. Don't just waive it and walk away, and don't waive the preliminary hearing. In one case, I stepped into a case and they had waived the preliminary hearing. And if you do waive the preliminary hearing, you can typically come back and say, no, I want my preliminary hearing. So these parents had attorneys that waived the preliminary hearing. I got back on the case. The first thing I did was ask for a preliminary hearing. We had 5 days of preliminary hearing, and I got all my discovery, right? I found out what everybody was going to say, all the witnesses they had, and they just kept going because they knew they didn't have much evidence. So they just kept putting people on the stand, and I found out who everybody was. And actually, by the time we ended the preliminary hearing, which did take, they did scatter the days out on us a little bit, so it did take about 4.5 days. But by the time we finished it, they were ready to take their toys and go home, because they knew that they weren't going to be able to present anything other than what they had already presented. The relatives and alternatives to placement, needs to always be reoccurring and forethought, and it needs to be pushed into the record over and over and over. And if they deny somebody once, because they love to deny relatives and alternative placements, just ask again and ask why. Why are they being blocked? Why can they not do it? And also at that first court appearance, they're going to set a team meeting, and I use the word team loosely because I have said in those meetings, and I've said, there is no team about this. This is your meeting, not our meeting. But that's where they're going to be, where they start setting all of the requirements on the parents, even before they've been adjudicated. I always say this is like going on probation for a crime you've never committed, but right now we have to deal with it. So at that preliminary hearing, I think parents need to ask the questions. Can you tell me where my children are? Can you set specific times to call and visit? And can we create an alternative like a safety placement? Ask those questions. Keep asking questions. And they don't always like it, but keep asking questions. And these are three great questions to ask at that very preliminary hearing. And you do want to get your visit set up, specifically phone and in person. And if you don't do it and they say we're going to talk to it at the team meeting, then say, well, between now and the team meeting, I want to get something convinced. Now, I have found most judges, even if they find probable cause and they are verbally asked for, a specific time, they will generally comply with that or try to do something. All right, so after the first court hearing, several things are going to happen. And this is where really the roller coaster starts going down the hill. And it seems to be going very, very fast. It's going to have hiccups in it, but it seems to start on a roll that's very confusing. So there'll be an administrative team meeting, which here sometimes they call it a CHINS, which is Child in Need of Services. Sometimes they call it a CFTM, which is a child and family team meeting, but it's some type of administrative meeting with the agency itself, not with the court. And also after this first hearing, the parent has got to set a time to talk to their attorney. They've got to start looking for relative placement and continuously looking for alternatives. Names and contacts of everybody from the very beginning. Who is the guardian ad litem? What's their phone number? What's their email? Who is the caseworker? Who is the foster care support person? Who is everybody? I mean, I think people should be carrying around a little notebook. I don't have one up here, but I used to have people get either a little composition book, which you can get for like $1 at the grocery store, or just a little spiral notebook, so that you immediately carrying it around with you, writing notes at all aspects at all the time. The persistence in persistent visits. Again, parents think at this initial involvement, there is a thought process that they're going to do the right thing. They're going to take care of things and that they'll make sure I see my child, and they don't do that at all. So the parent and the parent's attorney, if there is one, must persist, and advocate must persist in contact between the parent and child from the very beginning. This is also a really important time for the parents to do a self-assessment and for an advocate to help them with that. Like, are there some issues here that need to be addressed? Is there domestic violence? What do we need to do? How do we need to adjust that or work with that so it's a non-issue? Is there substance abuse? Is there environmental issues? Is there job and work skills? I mean, a self-assessment and a good advocate is going to help with that self-assessment from the very beginning. You may have a parent that you just know is not going to be able to make it. They're not going to be able to care for a child independently. It can be their own disability, or it can just be mental instability. But that first assessment is going to help give you direction. And if you don't do that, and if you watched our ADA, understanding this also has to do with disabilities, but if you don't do that, you're going to let them drive the ship. And so also after that first court hearing, there needs to be, the parent needs to be meeting with their attorney. Again, what kind of questions? Asking during these meetings, how can I communicate with my children? What can I do to make this better? And is there an alternative? Ask the questions, ask the questions. When I have participated with parents in a CFTM and they say, well, they need to do drug screens, ask the question, why do they need to do drug screens? They've not been accused of using drugs. If they say they need to give me a budget on their finances, I say, why do they have to give you a budget? They've not been accused of not having a job or not paying their bills. So asking questions has got to be on the forefront of everybody's mind. All right, so the first team meeting, again, record, get names, roles, contacts. There's going to be several people. There's education people, there's health people, mental health people, there's foster care people. There's probably going to be 7 people there from the agencies, and they go around the room very fast. Always have a pencil and paper taking notes while you are there so you can gather all that information. And then press for contact with the kids. What does FaceTime look like? What do phone calls look like? What do personal visits look like? Are the kids going to see each other? And check for conflicts. So in that very first team meeting, what kind of conflicts do you want to take note of? Is there a therapist in that meeting that's actually being employed by the department? You just want to know. You just want to take note about that so you know in the future if you need to follow up on it. Ask for a copy immediately. This is so important because if you don't ask for a copy of that team record immediately, sometimes it can take weeks before you get it. And also, you can't check it and see. They love to just ignore the fact that parents have completed certain requirements and they don't even record it anywhere. And so ask for a copy immediately. And then, of course, court approval, the court is going to have to approve whatever plan they have, which of course they always do. We know that, but you can get a hearing on it. All right, so the parents should be asking questions like, can you tell me who sets this up? Where do I need to go? Why is it necessary? How do I document completion? Asking questions, participating in those questions throughout the process. All right, getting the case prepared and doing discovery. So many people do not do their discovery in these cases, and you cannot know. It's like walking into a firing range with a blindfold on if you have not done some discovery. So the parent needs to understand what allegations are against them and what is the proof that they have of those allegations and who are the witnesses and what are the alternatives to disposition, alternative allegations that they may come up with. Who's going to be making these decisions? How can we speed it up? And how are the children going to be involved in just this process? Now, how can the children be involved? Well, sometimes the children are the accusers, good, bad, or indifferent. Sometimes it's disgruntled teenagers, and those disgruntled teenagers have to, make sure they want to get their say. Sometimes it's younger children. Maybe it's a child testifying about abuse on another parent or a step parent or a cousin. So the children are likely to be involved, but part of this process and discovery is to sit down and make notes and have a discussion with an attorney if need be about how do these children need to be involved? Do we need to do a deposition on them? Do we need to issue a subpoena for them to come to court? Is CPS going to be able to make its case if it doesn't have a child participate? So all of this is very important part of the discovery. All right, so in preparing sort of this discovery phase, who is the point of contact? So that means a couple different things. One of them, with the attorney's office, if they're working with an attorney, who should be the point of contact? Because honestly, sometimes attorneys have assistants that help them do things like put discovery together that they don't need to necessarily talk to an attorney about. But the other thing is the parents got to be willing to say, how do I help the attorney? How can I help the attorney? And how often should I report or meet with counsel? Ask them those questions up front. How often do you want to talk to me? Is it weekly? Is it every other week? You want me to just send you an email at the end of the week? How can we best communicate? And again, being proactive in that process. All right, now the role of the guardian ad litem is quite sort of flexes sometimes, I would say, to be kind and friendly. Most people will say guardian ad litems have subjective attitudes, that they have a mindset on their own, maybe because of their own experience as a guardian ad litem or because they're trying to please somebody else, but they typically already have a mindset about whether it's reunification or return to parent or foster care. And so as the parent gets to know the guardian ad litem, they're going to want to sort of eke out and try to find out like what the general attitudes are of the guardian ad litem. And sometimes they just come out and freaking say things like, I've had guardian ad litems say to parents, you will never get your child back, or your child doesn't want to come back, or your child's afraid of you, right? We want to eke all those out. We want to know what they are. The best interest is the standard. The guardian ad litem is supposed to apply the best interest standard. But the truth of the matter is, most people, that is just kind of an illusory thing. They're supposed to look at certain factors like who cares for the child, who provides food for the child, who's the child emotionally bonded to, et cetera. But rarely do they do that. It ends up sort of drifting downhill to this very subjective attitude. Again, document audio, video, have information on the kids. I have had parents who've been extremely proactive and they have gone to the pediatrician, they've gotten their records from the pediatrician, they've gone to the school, they've got the records from the school, they already know a lot of these. And who's important to the kids? You're going to want the guardian ad litem to know who's important to the kids. If your kids have an aunt or uncle or cousin that's close to them, you're going to want the guardian ad litem to touch base with them and reach out to them. And what are the safety issues? That guardian ad litem needs to understand what are the safety issues and who needs to address them. And then how often does the guardian ad litem engage with the children? Honestly, they go months and months and months and months without even seeing or talking to these children. But they should be talking to them. Honestly, I think they should be talking to them every other week, and most of them, though, are maybe a month, maybe 3 months, maybe 6 months. You just never know. There's no consistency. So again, questions to the guardian ad litem. What can I do to help? How can I help with this? And how often will you see my kids? And what do you see as important concerns? Engage in that conversation with people all along the way. All right, the Foster Care Review Board. This is an interesting issue. It's required by law to have a foster care review board, but here are some things to know. So first of all, the Foster Care Review Board is appointed by the judge. Okay, so if a parent feels a certain amount of hostility coming from the judge, there's a good likely that's going to trickle down to the Foster Care Review Board. There's no specific education requirements for a foster care review board. And again, important to document, audio record. A lot of them are there to defend the system. And they also, will ignore the parent's right to speak. And a parent has to persist in having the opportunity to speak. And then the child's right to speak, the child should have that input. Often they do not include the child, and then complete the report and file it. All right, so should a parent ask questions of the Foster Care Review Board? I say absolutely yes. Ask them to review the barriers of reunification. What are the reasons the children cannot come home? Ask them what you can do, the parent, to do to help, or an advocate, what can I do to help? Ask them if they have any conflicts. It's important to ask. They may be the judge's neighbor. You don't know. So you want to engage them. Now, the last time I saw somebody do a foster care review board meeting, they set 15 minutes for the foster care review board meeting and then would not allow the parent to speak at all. So that needs to absolutely be shut down, that type of practice. All right, facing the court process without fear. There is really facing fear in the courtroom is one of the hardest things, and it's so devastating, and there's good reason why, because it's hard to understand, it's difficult to deal with, it's unpredictable. Parents don't know what the next thing is going to happen. I mean, I've seen so much bad stuff in the court that it's hard not to tell people to face it with some fear. But as we go through and teach people what to expect, how to ask questions, teach them how to engage in conflict, we are moving them closer and closer to a point where they can face this court process without devastating fear. All right, so court approval. The CPS controls the placement of the children, but the judge has to approve the plan. This is a very odd setup. So CPS can pull a child out of foster care whenever they want to and send a child home or someplace else. They can do whatever they want. A judge has to approve the ratification plan. He has to approve the foster care review board plan. And so the judge has some involvement at that level. Now, the judge can do a judicial review of the foster care review board. And CPS is filing a court report, typically in secret. The guardian ad litem is filing a secret report. CASA is filing a secret report. And so I frequently have engaged parents to help them or order them to write a parent's report, which likewise gets filed with the court and then becomes part of the file. All right, so what are some important things about these reports, especially these secret reports? So you want to ask for reports in advance of court at least 3 days. I actually filed a motion to prevent CASA from filing secret reports with the court because they put in these reports what they want the judge to know, and they're not giving the truth, and they're not educating the court about the parents. And you always, always want to ask, what are the barriers to getting my kids home? Right, so how do you reporting task completion? So what documentation, who gets the documents, how does the judge know, how's it recorded? Do I give it to the guardian ad litem? Do I give it to CASA? And are there privacy rights with mental health reports? So I'm going to start with the bottom one first because it's very critical. Yes, there are privacy rights with mental health reports. If you've been compelled to have one, it is okay to question it. If ultimately you have to have one, there is the opportunity to ask to file it under seal, which means that nobody can have access to it except the attorneys and people involved. Now, the documentation on completing the tasks that have been required is so critical. It's so important to do that. And sometimes just CPS kept saying they didn't turn it in, they didn't turn it in, they didn't turn it in, and obviously they have turned it in. So we have this big gap of being ordered to do something, making sure the proper documents get returned. And how does the judge know? What does that? How does the judge find out that a parent has completed everything they're supposed to do? The only way that he can find out is if you get it properly before the court. And then how's it recorded or documented? Is the CPS marking it in the records, which they're not, I will tell you. Do you give it to the guardian ad litem and CASA? I think there's some discretion there that needs to be used. If there are privacy rights surrounding mental health reports, you want to file the privacy notice with the court. And these people could be getting themselves into trouble with violations of the privacy rights. So keep track of all of those things.
Honey, I have a question on that.
Yes,
What if the parent doesn't have the psych eval, but the worker keeps writing in because of mental health? Is that legal, even though they weren't diagnosed?
so there's a couple things. I have actually had parents independently go get a psych eval sometimes and filed it under seal or provided it or just held it until we go to court, right? I mean, you can hold on to it. If they do discovery, you've got a couple things. You can say it's work product and you don't want to disclose it or ask the court for direction on that. But if they keep saying mental health, somehow probably going to have to be some type of mental health provider involved in some way. Now, you could directly challenge it, which is going to be hard. I hate, depending on how critical it is, I hate to wait until, the final analysis or the final D-Day to have not done anything. And then CPS say, well, we're still concerned about mental health. So it's a tricky question. There are privacy rights, but I'm kind of looking at, I always look at the CPS process two-prong. I do believe people are entitled to adjudication, but my goal every time I meet with a parent, I'm like, I want your kids out of foster care. The sooner, the better. I will not plead guilty. I will not enter a guilty plea to anything, but I want the kids home. And so I want to remove all their barriers. Does that help?
Well, what I'm saying is I'm working with a case right now where they keep writing from the beginning. Mom has mental health issues. And because of mom's mental health issues, mom was never diagnosed with any mental health issues. So, how can they continuously put that in the report when none of them were doctors or psychologists to diagnose something? Isn't that defamation of character and cherry picking, I guess, too, on a way to keep putting that in a report to make it look like it's something and it's actually nothing?
Well, that's go back about 5 slides to discovery. And that's where discovery has to be done. And part of the questions, you can do two things. You can do a discovery for documents and records. You can also do discovery questions. And so a good attorney and even the parents can learn how to put these together. The discovery question to ask them is identify with specificity all you, and it would have to be more than one question. One is all mental health diagnosis that you are relying on to make a finding against the mother for a mental health disability. And then secondly is specifically what are the characteristics or behaviors or manifestations of that mental health upon which you're relying. Now, also remember our ADA thing. As soon as they raise mental health, you have to raise ADA. And so under ADA, what are you asking for in accommodations? You can ask in ADA accommodations that there be an explanation of how their mental health is interfering with their reunification.
But what I'm saying is there's no diagnosis of mental health. They keep saying it. There's
I know
nothing.
that's why you have to do discovery to
Okay.
them.
Okay.
You have to force their hand, okay? That's what I call it. You have
Okay.
to force their hand because they'll lie. I mean, it's not just that. They'll lie about drug screens. They'll lie
Oh
about
yeah.
substance abuse. You have to force their hand to do it,
Okay.
okay? That's why we've got to do discovery, and we'll talk about that, and we're going to prepare sample interrogatories and questions to try to make that easier, but discovery has to be done. All right, so, and these never, never, nevers come from everything I've ever told anybody when I've been involved. Never assume it will be easy. I will tell you my very first case where I thought it was nothing. I was like, these people have nothing, right? I lost the case because I had not prepared enough to defend these phantom allegations that didn't exist in the first place. So, one of my clients told me every time the other side lies, I have to pay you $1,000 to prove that it's a lie, which is true. So every single thing that word that spews out of their mouth, we have to we have to negate. That's like with what you're talking about mental health, got to do discovery to them. And then the parents are probably going to have to engage a mental health provider that can do an assessment or an evaluation. Also, in this process, never, never, never assume that people are going to tell the truth. Never, never, because that's the other thing. People and my clients would just go, well, if everybody tells the truth, there's nothing here, blah, blah, blah. I'm like, don't assume people are going to tell the truth. I never knew what liars were until I became a lawyer. I never knew people lied so much. And never, ever, ever assume the system is going to be fair because it just is not fair. We know from all these other trainings that I've done, there's all kinds of incentives and corruption and incompetence. You can't assume the government's going to be fair to you. And finally, never assume, quote unquote, they have no case. And that speaks, to what you're saying, Charlene. You cannot assume, oh, they have no case that I'm not mentally competent. No, they and in a courtroom with the judge, they're going to think, and this gets to case preparation that we'll talk about, they're going to think that they can just say to the judge, there's mental health issues. And so that is going to have to be dispelled by discovery, by forcing them, by getting a case prepared. Okay, so the trial on adjudication, you know, witnesses have to be subpoenaed. You have to do a pretrial report and disclosure. Witnesses have to be prepared. There has to be a determination whether or not there's an expert needed. You've got to be prepared to cross-examine caseworkers, and the parent has to be taking notes, particularly about false statements, because every single client I've said, look, you own the facts. I don't own the facts. So if you don't tell me the facts or you don't tell me something's a lie, I don't know. And then you have to be prepared to object and otherwise contest hearsay. And I'm going to give you a couple examples here. So the pretrial report, as an attorney, a lot of courts want what they call a pretrial statement. And so, especially if I was short, not having time to meet with my client, I would take all the bits of information that I'd have and I'd write a narrative, pretrial report. I'd try to make sure my dates were right, just look at everything that was said throughout the entire course. And then I send it to the client. And if you get it done in time, you send it to the client ahead of time and you say, is everything correct here? So they can double check it. But you also tell the client, you say, look, this is how you prepare. Because what's going to happen in the courtroom is everything that's in this pretrial report, we want to get in the evidence. So if I have things in there like the mother took the kids to the doctor on December the 19th, January the 21st, February the 23rd, I don't want you to get up in court when I say, when did you take the kids to the doctor for exams? And you say, I don't know, because you have to know, it has to be in the record. My pretrial report is basically a narrative and an overview for you to be prepared. Now, most courts, you're supposed to do what's also called a disclosure. And that disclosure is to find out what witnesses the other side has listed and what documents they have listed. This is critical because, again, if you've not done discovery, they can put anything they want on there. They can put the records, they can put drug screens. You've got to be prepared to object to things that you've never been provided. But if you don't do discovery, you have no objection. But if you've done discovery and you ask in discovery all experts who are going to testify, all reports and diagnoses, any past medical history you're going to use against this mother on her mental health issues, and then they put it on this and they give you nothing, and then they put on a pre-trial disclosure that they're going to give you an admission that she had to, for an acute psychotic event, back in 2015, you can go, whoa, 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 whoa. No, you're not. You're not going to put that in the record, and you can object to it ahead of time. Again, getting back to being prepared and getting ready. And experts, we've done another training on experts, but experts are there to give opinions on things like mental health, like education, whatever is needed. And cross-examining caseworkers, what does that require? That requires the fact that all during the entirety of this case, that there's been notes taken at the preliminary hearing, that every time the caseworker has talked to the parent, they have documented it, they've made notes about it, they've recorded it, so that we can shut down the lies that are occurring in the courtroom. The only way we can do it is be prepared in advance and have parents being proactive and participating in that. And that's what I mean about taking notes about false statements. And I'll give you a quick example of this, which was dynamic. So you all have seen Chad and Jessica show up on here sometimes, and I was doing a trial for them, and this detective was called in, and she talked about how she stopped Jessica because they wanted Jessica to appear in court and she hadn't shown up. And she said, oh, I stopped her and talked to her, and she was willing to come once I explained to her, and she got in my car on her own accord, and I just told her I was going to give her a ride. Well, I didn't know any better, and it hadn't really been an issue in the case. I mean, it wasn't about child abuse. And so after we walked out of the courtroom, Jessica and Chad said, that is all a lie. We have a recording of that. And Jessica had put a recorder down in her bra and she sent it to me, and everything was a lie. The detective had forced her into the back of her car. The detective had told her that if she didn't get into the back of her car, they were going to put handcuffs on her. And I immediately filed for the court to disqualify the witness and strike their testimony. And that was really kind of a turning point because I put the whammy on them that they had some credibility issues and they started backing down. If you can hit them during this process with a few things that are really, really strong, like are they getting their drug test lab confirmed? Well, they're not, right? And so you need to object. They can't do non-lab confirmed drug tests and take them to court. They are not experts. They can't testify as an expert witness on urine drug screens, right? Everybody has got to be objecting to those. We talked about those on authentication of records video. If you haven't seen that, please go back and watch it. And also hearsay, we've talked about hearsay objections and prior training, but you can prepare for that some in advance. If you know, for instance, you get the CPS case records and in one of the case notes, you pull it up and it's got, caseworker talked to the teacher who said the child was coming to school dirty and he was asking for food every day. Okay, the caseworker cannot come to court and read off of her records and notes. That is hearsay, and we've got to shut down bad evidence that is not evidence. And, I have talked about, sometimes I do this thing that, the absence of evidence is not the evidence of absence. The absence of evidence is not evidence. So you've got to shut down incompetent evidence. All right, so the clients and the parents have to be asking questions again, like how do I prepare? How can I help you prepare? What information will help you best? Okay. Parents can do things like parents can make a list of every place their child has medical treatment. They can make a list of their teachers. They can make a note about how their teachers help their kids or communication with their teachers. They can about their best friends' parents, if they have a Sunday school teacher. I mean, who are the people that the parents know about who can support their cause? They've got to be proactive in that preparation. Attorneys don't have time to be investigators. That's just the bottom line. Parents have got to feed it to them. All right, so the trial on disposition means that after there's been an adjudication that the facts are correct in the petition, there are still several things that can happen. So the kids can still go to their parents, or they can go to the parents with certain conditions on them. I don't see this very often, but the attorneys again should be asking for it. For instance, if it's a substance abuse issue that seems to be corrected, you can ask the court to return that to the parents and put conditions on them that they do drug testing, every so often, or they do have a therapist that they meet with the kids. Okay, so the return with conditions is really critical that not enough people engage with. Now, they can be placed with relatives voluntarily. Sometimes the CPS agency will do that. They can be still placed with fosters with still a return to parent goal, or they can be placed with fosters with a no return goal. And relatives can, if the CPS has not engage them in discussing placement, the relatives can become interveners in the case and actually file a little petition or motion to intervene. And if there are relatives who are out of state, the ICPC, which we'll actually have to do another entire training on, but the ICPC has to be followed up on. I did some of the reading I did this weekend on some of the future trainings to do is the ICPC reports. And what they're finding in the ICPC reports is basically people drop the ball. People just drop the ball. They file a request for an ICPC and then it's supposed to be done within a certain period. There's certain documents they have to gather. The ball gets dropped. And it can be things like making sure that there's a criminal clearance, making sure there's a home study done, making sure there's a financial statement. And I've done that. I've done private ICPCs before to be able to move a child out of state. So getting on top of that, if somebody goes, oh, well, we might consider the aunt in Alabama if we have an ICPC, get on it right away. Don't let any grass grow under your feet. All right, when the trial is over, unfortunately, we have a lot of bad things happen, but the appeal and the post-trial are still important. I mean, my thing is never, ever, ever give up, right? They don't want you to win, but the appeal in some states, like in Tennessee, on a dependency case, it's an appeal de novo, which means it goes directly to the circuit court. Or it can be an appeal on the record, which means that you just have to submit all the records, all the pleadings to the Court of Appeals, and then you write a brief. And you have to determine what are the issues that are going to be raised on appeal. Now, the appeal de novo is a little bit different, and the appeal de novo is much broader. De novo means brand new. It means start over. It means we're just going to start from scratch. And so you can start over this, if you've not done discovery here, do your discovery, right? If you've missed discovery, now you know what they're going to try to use against you. So we can still start from scratch. The issues on appeal on the record are a little bit different. And if the case has not been prepared and properly presented, for instance, you can't not do discovery and not have access to that information, go to trial and go, oops, I didn't do discovery. So I didn't know they were going to do this. You can't do it that way. Preparing the case and getting the case properly before the court has to be done, and the objections have to be made, and the evidentiary issues have to be raised, or you don't have an appeal. These people send me their appeals and, oh, it was fraud on the court. It was fraud on the court. I'm like, you're not going to get there from here. I mean, I'm not going to stop anybody from doing that, but you've got to have all those evidentiary issues preserved. Now, substantive issues are a bit different. And the substance of issues means, did they have enough proof given everything they have to make their case? And those are issues that, you can make sometimes without things that are being preserved. There's also what's called clear error, which means if there's a total due process violation, then those things can be raised. The transcript is, of course, the recording and the typewritten transcript of what occurred, who said everything. You have to watch those too because they leave out stuff, they change stuff. Inaudible, they put inaudible, inaudible, inaudible. I've had terrible things like that happening with court reporters for some strange reason. Inaudible, inaudible, inaudible. And then there's a statement of the evidence. And so the statement of the evidence is if you don't have a transcript, or if you have a transcript that is inaudible, that you can create a narrative of what that evidence would be. Okay. Now there's one last thing here. We talked about it before when we talked about evidence, but that is what's called an offer of the proof. So if you tried to get something in, and we talked about this, like I said, in evidence, but I'm going to just briefly touch on it here. Let's say you tried to get in a picture or something, and they wouldn't let it in. You can, after the trial is closed, you can file it, you can describe what it is, and you can say that it's an offer of proof and get it in the record. All right, now, how does this work? In a perfect case, it would look something like this. You would have the first knock on the door day one. The first 60 days would be preparing the case. You'd have maybe 60 days of discovery. All the agency tasks would be overlapping. You would have an adjudication in 6 months. If you have to appeal, it's going to take 2 years. All right. So in a perfect world, our case would be properly adjudicated and prevail. All issues brought up, all evidence on the record, from the knock to the prepare to the agency to the close, we would have a 6 months case. That's in an ideal world. But unfortunately, it looks more like this. Even for myself, you feel like you start here and you feel like you're heading in one direction. And then it just seems to go backwards and forwards and round and round and round. And so, but with all of that in mind, you always have to keep in mind what the process should look like. And you have to always try to be drawing it back on track. Okay. So if you feel like you're over here, discovery is not complete, you need to stop. You need to help the parents stop. You need to tell the attorney, look, we don't have discovery yet. You need to ask for that discovery. You need to get them to respond. You need to get us back before the court. The parents aren't having visitations, right? So you're flowing back over here. The parents aren't having any contact. Then the parents try to start doing the task that they thought that they were getting the task done. And then all of a sudden the CPS worker is not filing and putting down that the tasks are completed. So when all of this craziness is going on, it's an advocate's job. It's going to be an advocate's job to always try to pull it back on point, stay on point. What do we need to do next? What are the gaps? What's the holes in this case? All right, so through this process, everything seems topsy-turvy and inside out, just like I showed with that drawing. It's just, even for attorneys, and this is one reason why attorneys do a terrible job and why attorneys get burnt out on these cases, because the agency's job, part of their job is to create the confusion so it never makes sense to anybody. And we always are going, to encourage parents, just don't give up. Look for the next step. What is the next step? Now, when I talked about discovery, for instance, they may have the parents complete discovery too. They may send a request and say, give us all the answers to these questions. And we'll talk about that a different time because some of that needs to be complied with and some of it maybe does not. All right. So thank you again for your willingness to learn, your tenacity to fight, and the fortitude to never give up. And, for those who are not in the Family Forward Project, we are doing this through the Family Forward Project on Facebook and YouTube. Our goal is to reduce the number of children in foster care. We believe we can reduce the need for foster care by at least 1/3, if not more like 60%, and that we can make better, stronger parents, and that also then we want parents to be the voice. So our goal is to educate, to motivate, to activate, and to engage. And while you're traveling on this journey, prepare yourself to be the next voice for change. And then join our training on legislative advocacy and activism so you can be the voice for change. Legislators are ordinary people. They are ordinary people. Their job is to take the issues with families and parents and to help the system be better. All right, so I'm going to shut down our recording and then we'll have a chat.